46, I beg to appear for the respondent. But may I just make 3 sentences? Just want to bring something to the notice of this honorable foot. Yes.
Your Lordships had directed by 3rd February order. Your Lordships had directed the all 4 senior advocates to sit together with the parties. We all sat together and there was a broad consensus. Senior advocates are here. There was broad consensus that 100 seats your Lordships have reserved that can be filled as per the writ petitioners. And that the state may seek an instruction. The state is here. As far as there are 2 other issues which still remains there.
Others who had passed the examination,
they have been appointed.
Who have been appointed, they are not getting disturbed.
They are not getting disturbed. But there is one issue in that.
Writ petitioners are concerned. Those writ petitioners, with respect to them, about 100 posts are kept aside.
Yes.
So the broad consensus is that they can be accommodated.
They can be
there. May I?
2 issues remain.
Everybody is speaking.
May I now?
2 issues remain.
Whoever will ask that person will answer.
I have one writ also at some point. Yes. 2 issues still remains. Even if the 100 persons are accommodated as per your Lordship's observation and the state considers, 2 issues remains. One, those who have passed computer-based test. No. 7450.
Let the state say that.
So 7450 are confirmed. They took the examination, they passed, appointed. They confirmed.
Under 23.
Subsequent notification.
Under 23 rules.
Not
Correct.
Number 2, so far as the writ petitioners are concerned, for them, 100 posts are kept aside.
As per your Lordship's interim order of May 2025.
You need to say something.
We'll hear all of you, please.
Yes.
We'll go one after another. May 2025. So therefore, you are saying that appointments of those persons will be made.
That is for the state to take, and ultimately your Lordships to take it. This was a broad consensus in the meeting.
You will direct you to give them appointments.
Yes.
These petitions to the extent of 100 posts on the basis of the merit list that you will have, you will appoint them, right? Okay, what is the third?
Now the third is other groups which I broadly speak. Third is one. No, I'm not for the state. I'm for the petitioner.
I'm so sorry.
I'm representing number of IAs also.
But I want to say something.
Just
I wanted to say.
My writ petition. Can I just
ask? You thought he is appearing for the state. He always
no. Manish is here. Manish is here. He's.
Can you? How is he giving concession to somebody like that?
No, he thought he was appearing to the state.
No, I want to say what is a real fact. I want to say 4 sentences, so that your Lordship will get a broad idea what are we here for. But can I just say something? We are all
you. Yes. Why can't we?
But the state is not coming forward with the correct facts.
The state is here. They are here. They have participated with all the meetings, my Lord. My Lord, the broad. Yes. My Lord, the broad consensus, and your Lordship has rightly.
To have arrived at the consensus, we can.
No, my Lord, I'm coming to the point, my Lord. My Lord, so far as this observation of your Lordships, that the writ petitioners who had originally challenged the entire process on the ground that they should be appointed on the basis of 2018 rules, your Lordship is right. A direction can be issued to appoint them. It will come to a now the issue is. About 1,500 interveners have filed intervention applications.
We will come to that a little later. Therefore, this writ, so far as the writ petitioners are concerned, so far as they are concerned, apart from the first one, 7450, we can confirm even this 100 writ petitioners. Now tell us about the others.
Others, they are the interveners who are 1,500 in number. Now the total vacant position seats, this is 100 which a Lordship has directed and 113 non-joining posts. So total 233 posts are there. 233. 133 non-joining and 100 your Lordship has directed to kept vacant.
3,000.
So total interveners are 1,500. All these interveners who are now seeking appointment in this process, everyone has participated in 2023 examination process. And now they are saying that you treat me at par with the writ petitioners.
Okay, we will come to this. A contest is there. But tell us, what is the common thing that all of you sat down and
common thing, everyone has in principle agreed that yes, the state is right.
that only the no, my lord, because I do not have
line to like
my lord. I'm
come to the point.
because
I have to hear everybody.
Yes.
Come to the point.
The point is that if the writ petitioners are appointed, my lord, then the state may not have any objection as of now. But so far as the interveners are concerned, my lord, that
We get your point. So therefore, according to you, the appointed persons over and above that, the repetition.
Milord.
That's all, nothing more.
Milord.
Yes.
Lord, I am for the writ petitioner. Now, I'll tell your
What
lord.
are the original repetitions?
No, I'll tell your lordship.
But after our last suggestion, is there any common thing that
No,
arrived?
it will have to be argued. There is nothing common. Just 1 minute. Let me just broadly place why. There are a set of original rules of 2018. Advertisement is issued under the 18 rules.
See, Mr. Patwalya, if you are saying that eventually matter has to be heard, we'll hear it.
It has to be heard.
Only on one prayer, Lord. Can I make one prayer now? What the state came here and told this honorable court was, as if 100 posts, if they are kept vacant, interim stay can be obtained. Lord, the single judge said our writ petitions were allowed, saying that it has to be 18 rules because the 23 rules were introduced after our selection list was published. And therefore, we are all covered by Tej Prakash and subsequent judgments of this honorable court where they say changing of the game, changing the rules of the game after the game has begun. That was the point. Single judge in our favor. Division bench dismissed all their appeals. And then, one individual comes here and gets a stay order. State joins later. Anjali Kumari first comes. State comes later. Let me finish.
We will have, this is an argument.
Later.
Your lordship will have to hear it.
100 people alone will be sufficient is what the statement is made before this court. Your lordship therefore granted a stay, allowed them to make 100, keep 100 alone. Your lordship will have to know that 10,000 vacancies were advertised. We are about 7,000, 8,000 people who have succeeded and our names are in the selection list. How can the state graciously come and say here that, okay, I am now giving you a pittance of 200. Allow me to go ahead with the 23 rules. What are we? After 6 years, not the advertisement has come. For 6 years, we have waited and we are all in the selection list. And under the 2018 rules, you introduce a rule when my selection list is out. How is it that the 10,000 who are in the select list are not considered? And now 7,000 appointments made after getting an order from this court, Lord. They can't make any further appointment from today is my It will have to be heard. It's completely covered.
Can I not only indicate? Can I indicate something? This 18 rules.
When you want this to go.
Any day.
Only one line, Lord, I'll only one line. 18 rules resulted in the 22 advertisement. No, 22. Then 23 rules came, and there was a fresh advertisement which said that you can apply. No, 1 second. Those who had applied earlier will continue. Anybody else wants to apply can also apply. So everybody applied, everybody took the exam. I am below 100 of those people who are successful in terms of the 23 rules, and in spite of vacancies being there, I am not being appointed. On an erroneous assumption that they have to reserve posts for.
Anyway, state has vacancies. Everybody can be appointed.
Last order, yes, last order, your lordship said, those 100 plus all intervened. The intention of the last order was everybody gets accommodated, matter gets closed. State the
Earliest date.
15th of May.
15th of May.
15th of at 2 p.m.
Good. In the meantime, no further appointments so that somebody else is not disturbed in the meantime. No third party right should be created. Lordship can maintain.
The state is not taking appointment. That is our grievance. In
No,
spite of being, I am successful.
7,000.
I am successful.
7,000.
23.
They can't do. But after losing 2 courts, they can't make 7,000 appointments by way of this order that your lordship passed in last May. Please stall it from today.
When is accusing the court?
At least some 3,000 will be kept at least. Otherwise, all of them will be affected. Whoever is appointed will have a problem.
This is not necessary. There is already an affidavit of the state already there.
I am
But
successful.
let it status quo as on today at least.
All right, that's clear.
At least let them not make, at least make a statement here, Lord, that they will not make any further appointments.
My lord, after passing the order by my lord, my lord has passed an order in this matter. No fresh application will be entertained. Even thereafter, my lord, some application has been filed, my lord. I am also one of them, my lord.
These Now, while it was another case, you have now appears that it's not going to be settled.
Lord,
Going here.
Lord, let status quo be maintained, my Lord. Otherwise, they'll fill up all the posts, my Lord. Then it will become infectious for us.
Don't make any further appointments.
Take this here.
Status.
Lordship, I have filed an IE.
Pleasure.
Lordship, I have filed an IE after Lordship's order dated 3rd February.
There are two SLPs also in 46 below. 46.13 and 46.14. They may also be heard at that. Okay, I'm so sorry to interrupt.
Lordship, I have filed an IE after Lordship's order dated 3rd February. My IE number
We'll
is...
take it up at that time.
Okay.
Next.
Great.
Bharti Saman.
सुनवाई खत्म हो गया। फिर से लगता है डेट बढ़ गया, कुछ नहीं हुआ। आज का सुनवाई में आप लोग देख ही पा रहे होंगे कि आज हाँ डेट मिल गया, डेट मिला, फिर से डेट मिला।